God save the United States of America, state of Florida, and this honorable court. Please be seated.
All right, thank you, Marshall Crawford, and good morning, everyone. We are in session for oral arguments at the Sixth District Court of Appeal. Before I announce this case, let me introduce the panel and make a quick housekeeping announcement. As Marshall Crawford said, I'm Dan Traber. I'll be presiding today. Seated to my right and your left is the Honorable Petra Brownlett. Seated to my left and your right is the Honorable Roger Ganem. The housekeeping announcement is that we are streaming live via YouTube. So if you have not silenced your phone already, I would be truly grateful if you did. This case is 23-3172. It's John W. Mina, Sheriff of Orange County, Florida, versus Sean M. Hurley. Counsel, 5 minutes is the typical default that we do for rebuttal. Does that work for you, or would you like more or less? Terrific. Whenever you're ready, sir.
May it please the court. My name is Robert Hauser. I'm from the firm of Sniffen and Spellman, PA, and it is my privilege to represent the Sheriff of Orange County. And it is a pleasure to make my debut in 6th DCA. We're talking about a $20 million verdict this morning for mostly pain and suffering and non-economic damages. And with that verdict goes a 100% liability attribution against the sheriff vicariously for the acts of the deputy. In this trial, my client, the sheriff, proved that the plaintiff had operated his motorcycle knowingly, intentionally, without a working front brake. My client proved.
So maybe this gets to your cumulative error. You know, you've talked about 5 different bases for this, and you're not challenging the remediator. You're not. I understand that you are surprised, you know, by the jury's allocation of no comparative negligence and perhaps the damages award. But in terms of what you're asking us to do in terms of legal error, you've outlined 5 issues. Which do you think has the most heft or value to it?
I'm torn between the first and the second. I mean, I think we got killed by the citation evidence because I believe that when the jury learned that my client was cited, but didn't hear anything to sort of resolve that, they made the assumption, as I would, that if they were cited, they were fined or found guilty, and the Florida judicial system has already decided this. And so that was really bad for us, and we're probably in trouble when the judge told us that we weren't going to be able to let the jury know that that citation did not result in a fine or adjudication of traffic guilt. Like, I think that's a big problem.
Counsel, I don't know if you were trial counsel below in this moment, but there's no objection to that the minute that that comes out, right? I mean, so number one, isn't there a preservation problem with regard to that? And then number two, was it just strategic and the defense team really thought, well, we'll be able, you know, when we get up there, we'll be able to bring all of this other evidence out about the acquittal?
Well, there's no question that it's a preservation problem initially, because if I had been there, I might have jumped up and down and screamed mistrial, and the trial might have ended right there. But that's not what happened, right? The defense team said, okay, this has come in. We don't want to make a big deal about it in front of the jury, but we can always counter that and get back to neutral by letting them know that that citation, which is terrible evidence, is mitigated by the fact that that did not result in a adjudication of guilt. So the error, the court's right on the money here. The fact that the citation came in, nobody objected to that. But it's not like they were Boy Scouts and said, oh my goodness, Your Honor, we didn't mean for that to come in, and let's strike that. So they
wanted to do that, you know, and I get, you know, as a former trial lawyer and trial judge, the jumping up and down thing, you know, there's a way to do it. And isn't the way to do it at that point, hey, judge, can we approach? And just basically say, look, you know, co-counsel here didn't elicit this particular information, but it happened. I got to move for mistrial. You know, I got to object and move for mistrial. At that particular point, do you think that the trial court would have been in its discretion to grant it?
I don't know. And it doesn't bother me.
Because I mean, if the trial court was not in its discretion to grant it at that point, I don't understand your argument.
So I'm on board with the hypothetical. If I had been there, I might have sort of mumbled for a mistrial and had that in the back pocket for the judge to reserve in case the trial is a bad result. I could see that happening, but that's not our case. Our case is neither side objects, it comes in. And so now the question is, how do we address it? They've opened the door. That's our argument. That was the argument that this judge actually had before her. They opened the door, and all we want to let the jury know is that it didn't result in an adjudication of guilt, because that's the
So
assumption.
your argument is correct that not being able to do that, then you could not cure the prejudice that the defense suffered in that moment.
Correct.
So what do you do about the fact that there was other evidence in the case that it was clearly, and I think that Officer Rizzi himself mentioned that indeed Mr. Hurley had the right of way. And so if we have all of these concessions in there, aren't you nonetheless prejudiced by these statements? I mean, we have this, the officer saying the other guy, Mr. Hurley, had the right of way. And so wouldn't you have already been sufficiently prejudiced if that was the true concern?
Well, we already have the bad facts that my client had a stop sign, right? There's no question about that. My client had the stop sign, but that is not the same as the long arm of the law adjudicating him guilty of running a stop sign and failing to yield, which is my issue. So now the second part of your question, it's like really my second half of my answer to your question, is the directed verdict on causation.
Mr. Hauser, before we
Sure.
move on to that, I wanted to follow up on the citation. It seems like the fact of citation is bad, and the fact of acquittal is also bad for different reasons. And it strikes me as what you're asking us to do is to say it was an abuse of discretion for the trial court not to basically say that two wrongs make a right. On the one hand, the fact of citation could be misleading because it's simply a hearsay, issue. It hasn't been adjudicated. But on the other hand, if the fact of acquittal comes in, well, then we have the problem of, well, what, different burden of proof in that proceeding as compared to the civil proceeding. Why was there an acquittal? Was it on the evidence? Did the officer not show up to court? And it seems like you're just creating an additional problem for the jury instead of simply curing the first wrong with a curative instruction, which did occur here. So why isn't it better just to correct the one wrong than to allow a second wrong by bringing in the fact of acquittal? Seems like that makes the jury's job harder and less clear than the way that the court handled it here.
Well, I disagree a little bit. Like their argument is, oh my goodness, evidence of an acquittal is not admissible. Of course it isn't. But they've opened the door, so it has to come in. And yes, two wrongs do make more of a right than what we have here, where the jury is actively misled, right? This jury is basically defrauded into thinking a law enforcement officer cited the deputy, he is therefore guilty, because they never heard otherwise. And by the way, the plaintiff theoretically could have been cited because he was violating the law too, but the jury never heard that. So yes, in this particular cases, two wrongs do make.
Do you
a right.
acknowledge, though, my colleague's statement that this is a discretionary decision on the part of the trial court?
Within reason, except there's all this case law.
So do you also acknowledge that there's case law out there which says that it's an abuse of discretion for a trial court to open a door too big, too wide?
I agree, but I think
Okay.
the court has.
So if you've got if it's a discretionary decision, whether the door's been open, and it's a discretionary decision on how far to open the door, just address Judge Ganem's concerns that if you do that, you're effectively risking introducing a whole bunch of evidence and having a trial within a trial. Well, here's what precisely was introduced at the traffic citation hearing. Well, let's just read the transcript. And all of a sudden, you're not trying a personal injury case. You've imported an entire traffic citation with a different standard of proof and different actors with different motivations in it.
So I'm with you, and I don't disagree with any of these big points, but I think the court has to, know it when you see it. Look what I have here. I have a jury that's going back to the jury room thinking that citation unquestionably must have resulted in an adjudication of guilt by persons in black robes. Otherwise, why didn't I hear about it?
What do you
So
make of
that's-
the jury instruction that that trial counsel settled on?
It's okay and it's correct, but there's almost nothing that we could.
Would you have made it a little bit stronger?
In hindsight, probably yes, but there's nothing that could be done.
Was there anything suggesting that the trial court would not have signed off on a stronger instruction? I mean, she offered a curative, which your client rejected in the moment, in lieu of a jury instruction, and then seemed to be very wide, open as to what the jury instruction would be. Did she take what your client proposed?
Yes, we didn't object to the instruction, and I'm not here to complain about the instruction. What I'm here to complain about is the jury going back with the misimpression that the long arm of the law adjudicated my client's deputy guilty, which is the obvious inference, and nothing to counter that. Now, I don't like the idea of a trial within a trial. The only thing the jury needed to know is that that citation did not result in an adjudication of guilt, and they still need to decide who's right or wrong on the question of negligence and not be influenced by what happened in traffic court. But that's all. And anything else, I agree, is a mess, and I wouldn't suggest it. Now,
Do you have any case, counsel, where there's an analogous situation to ours with the witness just sort of offering this testimony instead of it coming out due to the specific questioning of counsel? I couldn't find that in the cases cited, and it seems to me that that this just came out, right? It wasn't precipitated by counsel asking the question. So what's your response to that? I mean, where's the case law saying that they have opened the door? Plaintiff's counsel very quickly told Judge Schreiber, I didn't ask that question, Judge.
I don't think there's any case law that says you have to intentionally open the door.
No, that's not my question. Just the fact that plaintiff's counsel did not ask the question in a way that required such a response.
I agree, they did not, but
But that's
nevertheless,
nonetheless opening the door.
it's not knowing they opened the door, but they did. And the evidence is out there and something needs to be done about it. And so the best case law that we did provide to the court is a mountain of cases that all demonstrate the terrible effect that having that citation evidence in the back of the mind of the jury is. And that's really the best we can do, I'm afraid. So I'm going to ask the court to make the leap that if all that evidence is terribly prejudicial under the case law, the jury has that, they retire to the jury room believing that my client has been adjudicated guilty of the citation, then they would have punted. Now, I really need to get to the directed verdict because it's probably just as bad. I mean, this judge took away from the jury the issue of causation, which really is the whole case, right? Here I am arguing that this plaintiff caused the accident by denying himself the ability to brake efficiently. Like there's no one in this courtroom who would get in a vehicle that didn't have an operative front brake. There's no one who would let a family member get in a vehicle that didn't have an operative front brake, especially a motorcycle type vehicle where there's no metal around you to protect you in a collision. So we proved that the front brake was more important than the rear brake and braking. We proved that the lack of front brakes contributed to the accident. But when we get to directed verdict, we have this dialogue. It's in the 870s of the transcript. So it starts out as them saying, we want a directed verdict that all the damages caused were caused by the accident. Now that would have been incorrect to grant because we know that the plaintiff had a pre-existing injury, but they got it. But this dialogue then morphed into something far more insidious. The trial judge walked out of this dialogue thinking that any negligence by the deputy is a legal cause of the accident. So any negligence. So even if my client.
Yeah, I don't know that that appropriately characterizes how the trial court came out of it, because there was a discussion about Lancheros and a lengthy distinguishment of it. So I don't necessarily know, and I'm sure you didn't mean it this way, but I'm sure that this wasn't a situation where the trial judge just ignorantly stumbled in with an inaccurate impression. I mean, there was a complete discussion about the case that you insist most benefits you.
I think the judge's language speaks for itself, and I'd invite you to look at page 882 of the transcript. There is no chance that the judge walked out of this ruling other than as I am characterizing. Now, how we got there, I may be misinterpreting what the lawyers are arguing to her, but I know that the judge walked out of that dialogue ruling that any negligence by Deputy Arisi is a legal cause of the accident. And that ended up in the verdict form and the jury instructions. And what really hurt us is that, and I don't blame them for doing this as trial lawyers, they went out of their way to show the jury that Judge Schreiber had taken away their burden of proof on causation. Any negligence by the deputy meant damages. So our whole argument that there's comparative fault here, that the plaintiff took away his own ability to brake is the reason for the accident. And if not the reason, a huge contributing reason. And instead, the judge put her thumb on the scale and said, defense, you have to prove causation, but plaintiff, you do not. And Your Honor, I do invite you to take a look at the judge's exact words on page 882, and then how plaintiff's counsel relied on that language to show the jury that there was an asymmetry in the instructions, whereas we had to prove causation that braking problem, or the fact that the plaintiff was speeding, or that he was probably wearing headphones. We have to prove causation for that, but they don't have to prove causation. If Deputy Urizi was negligent, same guy who was cited for failing to yield, if he's negligent 1%, that's the legal cause of the accident. So during the break, I'm gonna get the actual transcript and I will read it on rebuttal so that we have no misunderstanding.
You can use your rebuttal time however you want, but
Gotcha.
you have told us the transcript page twice. So use it however you'd like.
Maybe I can find it too.
Okay,
All right, I'm gonna reserve the rest of my time. Thank you, sir.
counsel.
Good morning to the court. May it please the court, my name is Brian Lee. I'm representing Sean Hurley in this case. Just want to start with both points that appellant's counsel has brought up regarding the citation as well as the causation argument. There's
It's okay with you guys. Can we focus on the second?
sure, whatever the court
Yeah,
would.
second first, please.
Yes, so the causation argument, Your Honor, if you look at the transcript, there was the directed verdict motion that was made by Mr. McLean at the trial very clearly talks about a legal cause. It does not say that we're wanting you, Your Honor, to say that every single bit of damages is caused by this. It's saying we are moving on a very distinct legal causation argument that there is no evidence to the contrary that injuries were caused by this crash. Now, what that means is that the second part of that question as to number one would then not be decided by the jury. And that's what the trial court did. The trial court essentially still had the question about whether there was negligence on the part of the sheriff's deputy. And that was, and certainly if the jury would have said no to that, that's it. So there was nothing about the conversation that occurred regarding the legal causation motion that I believe, I've looked at the record many times, that the trial court misinterpreted. And I think, Judge Traver, you talked about it specifically. This court was given the case of Lancheros and looked at it and at length distinguished it and talked about it. I also talked about the case, I think, of Wall versus Granger, the Supreme Court case. And I'm looking at 882. I'm not sure if that was the page that counsel talked about, but that's where the trial court distinguished Lancheros and very succinctly and said that, look, in Lancheros, we had a situation where there was evident that kind of the premise, and I'm speaking to the choir here, but the premise of Lancheros was that there was one injury, this back injury. And there was the expert testimony was undisputed that the back injury was caused by the crash. However, there was testimony regarding a prior chiropractic treatment of that back injury that was years prior to it. And then there was also evidence that Mr. Burke didn't see I think he was either any doctor really.
Anybody
for
18
about
days.
I think it was 12 days, if I'm
It was
not
18.
mistaken. 18. You're right, correct, Judge, obviously. And so that was the evidence that this court said, look, you know, the jury could have disregarded the expert testimony and found that because that evidence was in the record
That this accident didn't hurt this guy. That's basically it. That this is a soft tissue injury, that this accident did not hurt this guy.
correct.
I struggle with the argument from your colleague that there isn't evidence that this accident hurt this guy. I mean, his bones are sticking out of his legs.
True, Judge.
It's an open book pelvis fracture, you know, like, so in that sense, I wonder what evidence there is in the record. And I see where, and later on the trial court said, I wish you would have called my attention to that decade-old knee injury that apparently wasn't bothering him at the time.
Sure.
I don't necessarily know that we can read Lancheros as being equivalent to this particular situation.
I don't either, Judge. And the reason why is I think what you alluded to right from the beginning is that in Lancheros, and Judge Traver, I read your opinion again. I believe that soft tissue was a very big part of that. And so we're not talking about just
I mean, your client in that case, the defense's argument was he was not hurt by this accident.
that's correct.
I don't know how you can say in this case that this particular plaintiff was not hurt by this accident.
And I agree, Your Honor. And we know that they weren't doing that because I noted right at the beginning of the trial, an opening statement, defense counsel came up to in front of the jury and said, "We're not saying that he wasn't injured," meaning our client. So from the very beginning, I will say in fairness, there was a statement of the case which said you were contesting liability, causation. They were contesting everything. But the first thing out of defense counsel's mouth was that we know he was injured in this crash. That continuum went throughout the entire trial. There was zero evidence in this case that fractures didn't happen and that all the things that you are aware of, Judge, happened in this case. There was evidence regarding the left knee that was brought up. And there certainly was there, but there was absolutely no evidence that a fracture and the toes and all the way up through the legs, tibia fractures didn't happen in this crash. They didn't argue that. And so when the court at page 882 of the transcript is talking about that very thing gets brought up. The court said that this is distinguishable from Lancheros because we have a case here where there are fractures that happen. There is no evidence that fracture happened other than this crash, period. And throughout the entire arguments that were made, there is not one time that defense counsel even argues that, well, Judge, no, there really was this other thing that happened. What they're saying is that, no, we agree with all that. We agree that the fractures happened in this crash, all that happened. We're just saying that the left knee, we have some evidence regarding the left knee. And what the trial court didn't do, was the trial court didn't direct the jury that, well, if you find that the deputy was negligent, then that means you have to give all the damages that plaintiff is seeking. Trial judge didn't do that. The trial judge still allowed, and you can see from the record, that they argued about what the extent of the damages should be. That was proper in accordance with what Lancheros said, in accordance with what all the case law, even before and after, says that as long as you give the jury the ability to determine the extent of the damages, that a legal causation directed verdict is proper. And I don't think there was a sort of an intimation, and maybe I'm wrong about this, within the brief that, like, and this court did say that, look, these should be rarely granted. That was something you put in the decision, Judge Traver. And there's a sort of an intimation that, well, that really means that they should be never granted. And I don't think that's what this court is saying. I don't think that's what you said, Judge Traver and Lancheros. I don't think this court would be saying that now, because there are some situations like this very case where a jury cannot be allowed to make to give a verdict that is totally against every single bit of evidence in the case, and frankly, against common sense. And this is that case.
Mr. Lee, I want to ask about this asymmetrical jury instruction. Given that the directed verdict says the collision caused the injury, the instruction regarding the deputy was that if he's negligent, well, that necessarily caused the collision. But on the defendant's side, I'm sorry, on the plaintiff's side, the instruction was, well, if you find negligence here, the jury still has to find that negligence was a cause of the collision. What is different about the negligence alleged on the part of the deputy as compared to the negligence alleged on the part of the plaintiff that would allow that asymmetry in the instruction?
Sure. And I looked at that issue because I figured that was a question that would come up. I think where I begin, maybe even end, is that the plaintiff moved for a directed verdict on legal causation and was granted. Defendant didn't. There's nothing in the record where the defendant did, either before or after it says, well, judge, if you're gonna say that the crash caused the injury or damage or loss, well, then that should also be the same thing for the plaintiff. There was not, that didn't happen. They didn't make that link. They didn't make a motion at all about that. Now, I don't know whether the court would have granted that motion, probably would have, based upon what her reasoning was.
Would your firm have opposed that?
I can't see how we would have been able to, judge, because we can't on one hand say that, well, the accident, well, this crash, the crash itself caused a loss, injury, or damage to Mr. Hurley on one instance, but then say, but it's different when it's thing. Now, the argument that you did see that was talking about the negligence, whether there was actually negligence on the part of Mr. Hurley, whether, not wearing wearing earbuds, not having a front brake, was that, was there negligence by Mr. Hurley? That certainly was something that the jury looked at too. But to answer your question, I don't think we would have, I think there would have been in a different situation. Let's put it that way. If defense counsel at the trial would have said, well, judge, what's good for the goose is good for the gander, I think we should have a directed verdict too on that. And we should just be giving the jury questions about who was negligent. And that's it. And the judge said, no, I think that's different. And so I'm going to deny your motion. I think we would be on a different standpoint at the, then we'd have to argue that, but that didn't happen. And so the trial judge, of course, couldn't grant motions on its own, couldn't make a motion on its own. And so, and I'll note that when the court did go through pretty painstakingly the verdict form, the jury instructions, there was never anything brought up about that other than what had already been argued, which was specifically as to this whole, you can't grant a causation directed verdict because we had this left knee stuff. That was the only argument that was made at that point. So I think that this court can't now, even if it wanted to, go back and say, well, the judge should have done that because the judge was never even asked to do it. I hope that answered your question.
In part, I guess I'm just wondering if is it because the alleged negligence on the part of the plaintiff, the earbuds, the speeding, the lack of a front brake. When I look at those things, they may or may not have caused this impact. I mean, the reason for the impact was the deputy's vehicle was there, and you have the essentially, I don't, it might have been moving slowly, but basically this sort of immovable object and this, this motorcycle coming at it at whatever speed. So I'm wondering, is it because if the deputy was negligent, the only thing that negligence was responsible for was like putting him there, whereas the alleged negligence on the part of the plaintiff may or may not have caused the collision, and we heard, I guess there was evidence both ways.
Sure.
Did the lack of a front brake cause him to hit the deputy or not?
Yeah, maybe I misheard your question. I'm hearing what you're talking about. Yes, I mean, there was that, there was still that issue because we know that, like you said, the deputy coming out was the hit. The fact that there was still a question as to whether braking would have done anything, having front brakes would have done anything, whether the earbuds did anything to stop anything, right? So, I mean,
There weren't even earbuds there, right?
and there weren't even earbuds there, right? It was just sort of a supposition that was happening. So there is a situation that even, look, we're sort of hypothetically saying that, yes, I could see that argument being made by plaintiff's counsel that, we know that pulling out there, that hit happened, because that was what the negligence was of the deputy, not something he did prior to that, or not something irrelated to his vehicle actually going out. The negligence of the plaintiff, Mr. Hurley, that was put in front of the court was not that he saw it and ran right into it. or something. It was all these other things that they thought were negligent because he wasn't able to maybe perceive it in time or was able to stop in time. So yes, there still would have been that argument that would have happened, but I guess what I'm trying to say is that going back to what I said before is I don't know whether the judge would have made the same decision. But I can certainly tell you that if the judge had, if they would have moved for directed verdict, then the judge wouldn't have, and would have denied it, I would be arguing the same thing that you're mentioning, Judge Ganem.
I take you to agree that under the directed verdict as it was entered, that if the jury had said the deputy was 0% negligent, in other words, just wasn't negligent for being there, then that would have been, there's nothing about the judge's directed verdict ruling which would have prohibited that outcome, right?
Correct. Yeah, and that was the first question on the jury form. Yeah, absolutely. And I think the court sees throughout the trial that was the central, that was the issue that, now I will say, going to that specific question, Judge, that defense counsel, and I don't think defense counsel is going to disagree with this because it's in the record. The defense counsel in closing statement came up and told the jury to put negligence on the deputy. The closing statement of defense counsel said, jury, you should start at 50-50. This is very different than what they had said in opening statement. You should start at 50-50, and we think, defense things, you should put 87% on Mr. Hurley and 13% on the deputy. And so just from the way that this case was positioned to the jury, there's no surprise that the jury checked yes, because defense counsel was telling them to. So now, did they check no to the second question? Yes. They believe the evidence. They believe that Mr. Hurley didn't do anything wrong. And that was their decision. But this argument that's sort of laced in the brief that talks about all these things that happen and that caused the jury to check yes to the first question, I think is belied by the fact that their own counsel told them to, as part of his argument. So with that, there's nothing that we feel requires a reversal in this case, and we would ask the court to affirm, unless there's any more questions I can answer.
Thank you.
Thank you.
Brief rebuttal. So I found what I was looking for on page 82, 882, 883, and again on 886 of the transcript. Those are the PDF pages. And in each case, the judge ruled that if there was negligence by Deputy Arisi, it was the legal cause of damages. And that is the disputed issue in the case.
But isn't it true that if based on the evidence that was presented, that if the deputy was negligent at all, it was simply because his vehicle was there in that lane of travel that Mr. Hurley was in. Whereas the various negligence alleged as to the plaintiff were a whole bunch of things where, if the deputy was negligent for having his car there, clearly that was a cause of the collision. I mean, he was there. That's the only negligence alleged for him. Whereas the earbuds, the brakes, the speeding, all of those things may or may not have contributed to the accident. And so it's appropriate to ask the jury, did they or didn't they? If the deputy was negligent, it's because his car was there. There was no other kind of negligence. Like, he didn't have a speeding issue or a brakes issue or anything else that the jury would have to decide, well, did that contribute? If he negligently put his vehicle in that lane, well, clearly that contributed or was a cause of the collision, because, that's the only negligence alleged for him.
No, Your Honor. What if the plaintiff had brakes that work?
Yeah, but wasn't the testimony that the plaintiff he has the right of way, first of all, undisputed. He goes past am I correct? He goes past the officer comes out, clips him on the back. Mr. Hurley testifies, well, if he had hit me in the middle, I'd be dead, right? So he's trying to go kind of around him, right? Is that correct?
What's correct is that the plaintiff sped up because he knew he couldn't stop. And he attempted this incredibly dangerous move where he tried to go in front of the car. Your honor is correct. He got clipped and then he stayed upright, but he must have been out of control because he went several hundred more feet before finally losing his mount on the motorcycle.
So why would brakes then? Because your comment to Judge Ganem, I thought was, well, if his brakes had worked. You're presuming that he just would have braked before the officer pulled out, even if
Yes.
he has the right of way?
Yes, he could have stopped. He could have avoided this accident.
We
That's the-
still had the rear brakes, right? And those are stronger supposedly?
No, the evidence is the front brakes are the ones that matter. They're the stronger brakes. So he had to do this contrivance where he tried to use the transmission of his motorbike to slow down in conjunction with the rear brake. So our whole point is this plaintiff intentionally increased the kinetic energy of this collision because he knew he could not stop. Most people, and this is a jury question, most people could have just stopped and avoided the collision, whether Deputy Arizi was in the wrong or in the right. So the whole problem here is that it is unclear, and it was a jury question, and this court hit the nail right on the head. It is unclear, and it was a jury question, that even if Deputy Arizi negligently operated his vehicle, that it would have resulted in an accident. Because we've got a plaintiff who should have been able to stop. And if he wasn't able to stop, he should have been able to decrease the kinetic energy of the collision. And it's also unclear on our side. Even if Sean Hurley was negligent, could he have avoided causation? We don't know. Those were jury questions. So my problem with the asymmetry that this court has acknowledged is Judge Schreiber is telling the jury that any negligence by Deputy Arizi is a legal cause of the accident. And she's not telling the jury that any negligence by the plaintiff is a legal cause, and neither is a legal cause.
Did you ask her to make that? Because I think Mr. Lee's point was, well, the defense never asked for her to make that, give that instruction to the jury.
And that would have been a completely frivolous request, and no defense attorney in a straight face would have made that request. And his concession, I find to be remarkable. There's no way that we would have asked for that. There's no way we should have got it. And that's the same reason why they shouldn't have got it. I mean, Lancheros is kind of a red herring here because it's worse than Lancheros. We already knew that this guy had a pre-existing injury. And so the accident is not the cause of all his injuries. It's only the cause of some of them. And it's up to the jury to figure out which ones. But when Judge Schreiber
Was there any evidence that Mr. Hurley was driving down that street before the accident with a dislocated knee?
only his testimony that I quoted that he had a pre-existing knee problem.
Not my question. Was there any testimony adduced at trial that Mr. Hurley, before the accident, was driving down that street on his motorcycle with a dislocated knee? Was his knee dislocated before the?
That does
before the
not
accident?
ring a bell for me, so I'm gonna guess no.
Okay.
I have to rely strictly on what's in the record about his pre-existing, it's almost a young adult knee injury, so.
Right.
Based on the errors that we've identified, in conclusion, we urge the court to remand for a new trial where the citation evidence is on a fair playing field. Either it doesn't come in at all, or both sides get to show the jury that it was not pre-existingly resolved. And there should be no directed verdict on causation for either side because it stacks the verdict. Here it stacked it
You
100%.
sounded like you were wrapping up, but it doesn't sound like you are anymore.
That really is. That really is.
All right. Thank you very much, both of
I
you, for your
appreciate the
presentation.
kind attention of the panel.
Yeah, of course. We're going to take a